Well, hello and welcome to Court Corner. I'm Ashmit Kumar. The Supreme Court has observed that the issue of legal recognition for same-sex marriage in India is of seminal importance, and with that has referred the matter to a 5-judge constitution bench. Now, final arguments would be heard on the 18th of April. The centre, on its part, has opposed pleas seeking legal sanctity for same-sex marriages. In its argument, the centre contended that heterosexual marriage is the norm in India and asserted that right to love is not the same as right to marry. However, the centre did not term it as unlawful either. The centre has also argued that giving legal recognition would involve a lot of complications in marriage, divorce and other personal laws. Petitioners, meanwhile, have argued that the narrow, pedantic view of the legal provisions restricting marriage to biological man and woman are no longer tenable. They have also sought live streaming of court proceedings so that the stigma surrounding same-sex marriage can be removed. And well, joining me now to take this discussion forward is Narula. She's an advocate for one of the petitioners. And also with me is filmmaker and activist Sridhar Rangayan. Mr. Rangayan, Ms. Narula, thank you so much for joining us. Let me come to you first, Mr. Rangayan. As far as today's proceedings are concerned, it's interesting that the top court, the bench headed by the Chief Justice himself, has noted in as many words that, look, this is an issue that involves rights. This is an issue of seminal importance and perhaps deserves to be heard by a larger 5-judge bench. What do you make of these initial indications coming in from the top court, Mr. Rangayan?
It is definitely hopeful, and I have a lot of faith in Justice Chandrachud and the 5-member bench they're going to constitute. But it's taken really very long time. The Supreme Court decriminalized homosexuality in 2018. It's already 5 years now. When do we get to marry same-sex partners? I've been living with my partner for the last 28 years. 28 years, which is much more than any heterosexual marriage. But we're not allowed to marry each other because of this particular law. So we definitely need same-sex marriage rights to come in so that I can marry my partner. We've been living together for 28 years. Everybody knows that we are a couple, except the law, which is not recognizing us yet.
Let's get a legal view on that, Ms. Narula. Thank you so much for joining us as well. The words that have been used by the centre in its affidavit to defend its position of opposing same-sex marriage, the words have been like sanskar, Indian family unit, sanctity, social order, wreaking havoc. These are some of the words used as a defense of why there should be no recognition of same-sex marriages. These words, these ideas that are being propelled here by the centre, will they withstand judicial scrutiny?
I believe not. And I actually think that, they have used the phrase that marriage can only be between a biological man and a biological woman. As on date, there is no legal standard for what is a biological man and what is a biological woman. And I can be corrected by more knowledgeable people, but I believe there's no medical standard either that is used to determine any such criteria for when two people are getting married. I think the arguments in the counter affidavit would be unsustainable also on the basis of judgments that have already been passed by the Supreme Court. In, of course, the Navteej Johar case, which decriminalized homosexuality, or rather took homosexual acts outside the purview of Section 377 of the IPC, and other judgments such as NALSA, which pertained to the rights of transgendered persons. So I think one of the important takeaways from these judgments is that a full bundle of civil rights without exception attaches to LGBT persons, LGBTQ persons, and those civil rights include the right to marry and to found a family. This has already been held by the Supreme Court. So I think the counter filed by the government may not stand the scrutiny of the court, given its past judgments already.
Sure. Mr. Rangayan, let me come to you, and this is from, in fact, an argument that was cited by the Solicitor General himself while advocating against same-sex marriages. And he was referring to the landmark Section 377 judgment, that is a judgment of the Apex Court that decriminalized Section 377 and thereby allowing for consensual sex between homosexuals. The concern here is, what the centre is saying is that, look, you're free to love, but not free to marry. That is the stance that the centre has taken before the top court. What is your understanding? Is there a distinction between the two You're free to love, but not free to marry.
It's very stupid, and I don't understand what the government is saying when it says wreaking havoc. How can marriage wreak havoc? I don't understand this. And for me, more importantly, what is important for me is myself and my partner have been living together, as I said, for 28 years, and we have no right over each other's body. When I'm in the hospital, my partner cannot sign for me on any medical papers. For me, that's really crucial. If we are being together, he should have the right to sign on as a kith and kin, as a family member. So for me, the right to marry is more important in terms of, I would say, having a right over each other's body. Then, of course, the right over each other's property and inheritance, all that comes into picture later. For me, the primary issue is right over each other's body. And basically, we want to live together forever, for till we die. And we should have the right to sign in the hospital for each other's medical purposes. For me, I don't want a big fat current your wedding, current your film kind of wedding, but I definitely want basically to marry my partner whom we've been living together. And also, like, everybody has accepted us, except the government and the law. How long will it take? And I'm already 60 years old now. If I don't marry now, when will I? I really think that the government of India, the political party which is heading the government, needs to update their own moral statistics per se. I don't think we should be, homosexuality is not against any morality. We are Indians, we are Hindu, we are Christians, we are Muslims, and we basically believe in the faith. We also believe in the society.
Sure.
And we should have the right to marry and live like anybody else. What is normal has been kind of thrown out of the windows long back. So we need to really consider that, like, we need to be, I would say also, that as the lawyers advocate said, what is biological male, what is biological female, has been in question right now. The gender fluidity is really, among the youngsters, gender is fluid as a construct. So really need to look at all these things. And also we need to look at, like, how do
Sure, Mr. Rangayan.
Okay.
Sure. Mr. Narula, let me get you in on this conversation. And this is a logistical argument that was put forth by the Solicitor General that, look, marriage is as much a private institution as it is a public one. There are issues of divorce, of separation, of alimony, of inheritance, of adoption, and that this will require tweaking a whole host of rules as well as regulations, as well as laws and statutes. The argument being put forth is that, look, since so many laws are to be amended, and since amending is a function of the legislature, leave this to the Parliament and leave this to the wisdom of the people, the collective wisdom through the Parliament, and that the court should have no role to play here. That is the argument that they've put forth. What is your take on that?
Well, my take is that they better get started. They've already delayed it long enough. My other take is that, it is not like people are not living full lives or people are not living with a partner of choice already. They are just stymied on account of inaction of the state from accessing certain rights which flow from the institution of marriage. For example, like it was said, property rights, banking, opening a bank account is a problem, medical decisions, who's going to take, adopting as a couple. As on date, there are adoptions of all kinds happening across the country. It is by no means only married couples that are adopting, only heterosexual married couples that are adopting children, but only one of the two will have a legal right over the child, and that is problematic for the child. It is not what the solicitor said in court today, with respect, is absolutely offensive in that he said that the effect on biological children of such marriages would have to be examined, gone into by the Parliament. The Parliament is not expert on this kind of psychology, and they can't enter into that discussion. There are apart from social injustice driven, biases in society, there is no other possible pathologizing of a child of a gay couple.
It's interesting you mentioned that comment. It's interesting you mentioned that comment. The CJI was quick to correct. The CJI was quick to point out to the Solicitor General that the adopted son of, say, a gay couple need not necessarily be gay himself. And that was, of course, came as a rebuttal to the argument that had been put forth by the Solicitor General. But we're running out of time. Ms. Narula, final question here. Do you find some solace in the fact that the centre has said as a part of its affidavit that, look, while we're not recognizing same-sex marriages, it is also not something that is unlawful? Do you find some solace in that? Is there some hope that perhaps that is the trajectory that the government may perhaps set itself on?
Well, I think it's they have accepted wholesale the judgment of the Supreme Court in Johar, and they say that to love is not a crime, and to love is acceptable. And I'm happy to hear that the solicitor thinks that there is no stigma attached to same-sex love in this country. But insofar as marriage is concerned, I do believe it comes within the purview of the state to ensure that rights, liabilities, and privileges that stem from marital status actually extends to all persons without exception, because that is the constitutional mandate. Article 14, Article 21, Article 19 of the Constitution, the fundamental rights parts, do not say apply only to men and women. They say persons. And that's how it has to be done from here on in.
Sure. We're completely out of time. Mr. Rangayan, let me come to you for a quick 30 seconds final question. The Supreme Court, by making this a constitutional bench hearing, also implies that this will now be live streamed for public across the country, not just the lawyers and the petitioners in this case. How big of a takeaway is that in terms of media attention, and public scrutiny on this one very polarizing issue? 30 seconds only, Mr. Rangayan. We're completely out of time.
Thank you. Yeah, I really think society plays a very important part, and the society has to be involved in all decision making. And I'm happy that live streaming has been enabled, and everybody can be watching it and contribute to the opinions online on social media. That's a great improvement on the status quo per se.
Right, Mr. Rangayan, Ms. Narula, thank you so much for sharing your insight with us. This, of course, will continue. These conversations will continue. The Supreme Court is set to resume hearing in this case, a 5-judge bench on April 18th. We'll, of course, keep tracking the developments out of the top court. But with that, it's time now to slip into a very short break. But coming up on the other side, we have a special story of how a hearing-impaired businessman is trying to make movies and news more accessible to the deaf community when we come back.